Hello, my name is Julia, I'm Hungarian. I'm going to tell you about a conference on abortion that I attended yesterday, November 23rd, in the European Parliament. You can listen to the conference in the following video. It was organized by a courageous Spanish MEP, Margarita de la Pisa, together with the NGO European Centre for Law and Justice, ECLJ, in the presence of MEPs from several political groups. This conference triggered the anger of the left, who tried to intimidate us with an illegal demonstration in front of the parliament and then inside the parliament. MPs and officials blocked the corridor to prevent us from attending the event. Some people who wanted to attend the conference were shocked by this harassment. Fortunately, the security prevented them from entering the room and further disrupting the event. This behavior of MEPs and officials is a violation of the European Parliament's rules of procedure. They should therefore be sanctioned. There were more than 100 of them. Among them, I recognize many French MEPs, socialists, ecologists and Renaissance. Fortunately, as you will see, the conference took place and I was able to participate by entering through a back door, protected by the security of the parliament. The conference focused on women and children to protect them from the violence of abortion and pro-abortion activists. Dr Puppinck, director of ECLJ, spoke about the situation in Europe, the lobbying of abortion industry and the need for a policy of abortion prevention rather than promotion. He is based in Strasbourg and has been intervening for more than 20 years, notably at the European Court of Human Rights. Then came the outstanding intervention of Dr Ekonomou. He is an attorney at the American Center for Law and Justice, ACLJ, in Washington. Mr. Ekonomou outlined the state of abortion in the United States since the 1970s. In particular, he commented on the implications of the Supreme Court's Dobbs decision in June 2022. I hope you enjoy listening to this lecture.
It's very normal to see the welcome we've had. We see the contrast between the right to life and the abortion rights campaigners. We have values that are rooted in Christian culture that have made us who we are, the success that we are, and has aligned itself with the law and meets the reality of people. The fundamental access is dignity to all people, in all circumstances, at any time in their lives. And we pay special attention to the mystery of the beginning of life. People are unique and have a purpose and a sense in the world. A person in his mother's womb has those rights, and it's very important to acknowledge those, which is how I don't understand how someone can turn their back on that and disregard it. All our rights rest on this basic truth. We all have the right to exist and to live in the world, from conception to a natural death. Otherwise, there would be despair in the human heart and not allow people the development they're entitled to. Life has been materialized, rendered frivolous. We consider it a good, something that we can do without, as happens with abortion. We have some illustrious rapporteurs here today who will present the defense of the right to life in opposition to abortion from a legal perspective. Whether these people are from Spain or from Europe or from the US, they have been able to contribute. The US has revoked Roe versus Wade of 1973. In the EU, we have the challenge whereby people are trying to get abortion rights included in the Charter of Fundamental Rights. And as will be explained, in Spain, we are currently awaiting a new bill on reproductive rights. So the order of the agenda today is that we will first see the situation in Spain, and then the US. But first, Dr Puppinck, who in 2016 was named leader of the panel of experts on the OECD and was an expert advising the Holy See. There are too many qualifications for me to list here, in fact. Suffice it to say that it would take me hours to go through all the qualifications adequately, but he has written many books and legal articles that have been published in many languages. He is Cavaliere della Repubblica in Italy. He has various honors, and he has always fought in the defense of human rights and the right to life. He has been committed to bestowing upon the law the spirit of Christian humanism. I give you the floor now so that you tell us how things stand from the European perspective.
Muchas gracias. Merci beaucoup, Madame de la Pisa. Thank you, everyone, for being here. It's a great honor and pleasure to be here with you to speak on this important issue. Often, proponents of abortion claims that men have no word on abortion, that we should stay silent. I don't agree. I think that as human being, it is my duty to speak up and say the truth, for the sake of the women, of the babies, and of the society. Abortion concerns all of us, because a baby is one of us, because men and women are inseparably united in all aspects of life, and especially in the greatest one, love and the gift of life. We all, men and women, have the moral responsibility to address this devastating scourge. To this day, more than 1 billion abortions have been accomplished worldwide. Every year, abortions put an end to a third of European pregnancies, with 4.5 million abortions against 8.5 million births. Considering the scale of the phenomenon, its cause and its consequences, abortion is a major social problem of public health to which society can and must respond. It must be mentioned from the outset that the main cause of abortion is not the pregnancy itself, but the context in which it occurs. A woman undergoes an abortion not primarily because of the pregnancy, which is only a triggering factor, but because of particular circumstances, and the same woman placed in other circumstances would not necessarily resort to abortion. Abortion is thus a result of a combination of circumstances for which society is in part responsible. In fact, 75% of women who have undergone an abortion indicate having been pushed to do so by the social and economical constraints. The decision to abort often results from coercion that can take diverse forms. There are the social and medical constraints and pressures, the pressures and the irresponsibility of the father, the pressures exercised by the family, in particular on poor or minor girls. There are also the pressures of the employer and all the material pressures. These constraints weigh directly upon the liberty of women and couples. To claim, like an official truth, that abortion is an individual freedom is an ideological error. It separates the question from its real causes and in the end leads to making the woman feel guilty, since this violence apparently results from her own will, from her own freedom. If abortion is but a freedom, an individual choice, then the woman is fully responsible. It is to leave her alone in the face of a violence, both guilty and victim, in an inextricable psychological situation. when this violence is largely generated, in fact, by the circumstances. One mustn't be surprised that abortion provokes so many psychological disorders, depressions, and suicidal ideas, particularly among young people. 42% of women who have had an abortion before the age of 25 experience depression. Half of the underage women who have had an abortion suffer from suicidal thoughts. Women who have had abortion are 3 times more likely to suffer psychological, mental, or sexual violence than women who have carried their pregnancy to term. 90% of French women recognize that abortion leaves psychological sears that are difficult for women to live with. And 72% of women believe that society should do more to help women avoid having an abortion. We see that abortion hurts. It is not a concept. It is not an abstract freedom, but a bloody and harsh reality. And it is absurd to pretend that it is a kind of fundamental human right. Abortion will never be a true human right, but only a violation or a derogation to the right to life, because there cannot be any right on the existence of the innocent human being, whether you call this being potential or not. Moreover, and put simply, if abortion were a true human right, it would give joy and not cause sufferings. And we could show an abortion with pride. As well, the fact that a significant and increasing proportion of medical practitioners refuses consciously to practice abortion demonstrates that this practice is generally immoral. And here in Strasbourg, the European Court of Human Rights repeatedly declared and very clearly that the European Convention of Human Rights cannot be interpreted, I quote, as containing a right to abortion. The same is true of the United Nations, where various committees look at abortion as an exception to the right to life and never recognized any right to abortion on demand. The ECHR also declares that a state can, I quote, legitimately choose to consider the unborn child as a person and protect his life. So, what should we do? What is the way forward? On one hand, we have to fight and defend the society against the relentless lobby of the abortion industry, which pushes for more abortions always. On the other hand, we have to promote public policies aimed at preventing abortion. We need to do both. First, defending the society against the abortion industry. The abortion industry and lobby have billions of dollars and are deeply infiltrated within international institutions, including this Parliament, but also the World Health Organization, the UN, or even the ECHR. As an illustration, the abortion industry and lobbies finance massively the WHO division in charge of population control, as well as they employ and finance several UN experts. They employ them. The UN expert on the right to health is a professional militant and practitioner of abortion that describes abortion, I quote, as a radical act of self-love. This person has been appointed to this top UN official position because of her commitment to abortion. The abortion industry has a very simple agenda: always more abortions and more public funds. They push for abortion without limits and for any reason, everywhere, anytime, even during delivery. Regarding the money, keep in mind that the abortion industry gets paid for each abortion they do, and that they own patents on many abortive and contraceptive pills and devices. It is a huge business, in addition to being a huge issue in regard to controlling the demography of the poor countries. They are not Democrats nor liberals. They are not Democrats. They do not allow debates on abortion and often use intimidation, verbal and physical violence in order to silence anyone willing to defend the victims of abortion. Abortion has been legalized in many countries, not through parliaments, but through judicial activism, generally against the will of the majority of the population. This is why the US Supreme Court Dobbs decision is excellent. It sends back the issue to the people. The promoters of abortion are not liberal either. They push to deprive medical practitioners from freedom of conscience, to deprive the parents from their responsibilities and rights, to push to suppress the freedom of speech against abortion. They push to forbid pregnancy help centers. They litigate in courts in support of racist, sexist, and eugenic abortions, as well as to support partial birth abortion and neonatal infanticide. They are not only against life, they are also against freedoms. They are not Democrats nor liberals because they know that abortion on demand is intrinsically immoral and not defendable. This is why they want to make it a dogma through its inscription into the EU Charter and the national constitutions. However, it will not change the very reality of abortion. This is a pure legal positivism. So, against the abortion lobby, we have to defend true human rights and justice in courts and parliaments on all fronts. On the other hand, as I said, we have to promote public policies aimed at preventing abortion. We have to understand that abortion is not a fatality. Several countries have managed to reduce the recourse to it through prevention policies. In Italy, for example, the number of abortions fell by more than 50% in the last 30 years, reaching 100,000 abortions per year, which is half of France. In the US, the teenage pregnancy rate was reduced by half between 1990 and 2010. The same is true for other countries. Currently, the social and pro-life policy implemented in Hungary shows that this is possible. Just in the first 5 years of this policy, between 2010 and 2015, the number of abortions in Hungary fell by 23%. In the meantime, there are twice more marriages and more births. This progress was reached without changing the law on abortion. Reducing the use of abortion is not only a duty for the good of women, children, and society as a whole, it is also a legal obligation undertaken under international law. The governments committed to provide, I quote, protection and assistance as broad as possible to the family as long as it has the responsibility of maintaining and educating children in its care. States thus have the obligation of providing support to women and couples who do not feel capable of welcoming a child. States also have committed to protecting motherhood before and after birth. Thus, for example, by ratifying the International Covenant on Social and Economic Rights, states recognize that, I quote, special protection should be accorded to mothers during a reasonable period before and after childbirth. States have also recognized through the Convention of the Right of the Child that, I quote again, the child by reason of his physical and mental immaturity needs special safeguards and care, including appropriate legal protection before as well as after birth. In a more precise manner, states have undertaken the commitment to reduce the recourse to abortion. In that respect, during the International Conference of Cairo in 1994, the governments committed to, I quote, reducing the recourse to abortion, and again, to take appropriate measures to help women avoid abortion. The Council of Europe also called member states to provide concrete counseling to help women who are asking for an abortion because of familial or financial pressures. A policy of prevention of abortion must answer the social and economic causes because of which a pregnancy comes to be called unwanted, like effective immaturity, fragility, economic precarity, and so forth. To most of these causes should normally respond the different social rights that the states committed to guarantee. Indeed, the European Social Charter guarantees these rights, in particular the right to accommodation, protection of the family, of the motherhood, of the life even before birth, and of conciliation between family life and professional life, and so forth. So, while the pro-abortion industry continues to push for always more abortions and money, there is, on the other side, a lot of good work to be done in order to prevent abortion and to help and support women and families. As a result, I'm convinced that reducing abortion will be beneficial to all of us. I thank you.
Gracias, Grego, por mostrarnos una realidad.
Thank you, Gregor, for showing us a reality that prefers to remain hidden and that can't often be heard. We cannot allow abortion. Often, economic and social circumstances push women towards abortion, and we have to ask ourselves whether that decision is actually free. You talk about freedom, but is that woman who decides to have an abortion, a complex situation, truly free? Often they are alone, and we have a social duty to her. But we do the opposite. She is vulnerable, and we leave her in the hands of those who do have an interest in the abortion industry. It's a very lucrative industry, and pregnant women just need to have their hands held. They need to feel safe, they need affection, she may need help with her situation to welcome life. If a state has policies that do this, that hold her hand, that help her, then we will see, as has happened in other states, that the number of abortions goes down. We've seen the situation in the US when they've refused to consider abortion a human right, and some member states have changed their attitude. Then they've had a different attitude towards welcoming babies and pregnant women.
Well, today we have the honor and the luck of having Dr Ekonomou with us. He's come from the USA to tell us about something which we thought was a great interest at the beginning of the summer. We were waiting to see how the Supreme Court was going to deal with it. It's an honor to have him. He's a senior counsel at the ACLJ. He's written a report on the Dolph versus Jackson Women Health Organization case. He worked at the Georgia Chamber of Representatives up until 1975. He was an assistant to the Public Prosecution's Office in Georgia and in the Department of State, and he recently was working for the District Attorney in Georgia. He often speaks for the American Center for Secular Life. We're very happy to have someone here who's had an active role in protecting life in the US. He's had a wealth of experience in public life in the USA, and it shows the energy he has put into defending values that go towards a better society, mainly when it comes to protecting life. We'd be interested in hearing what guidelines he can give us to find the way in Europe to revert this idea that abortion could be a right.
Ladies and gentlemen, the United States has long been out of the mainstream in the international community on the issue of abortion. Until recently, the U.S. was one of only a few countries to allow abortions for any reason beyond 15 weeks of pregnancy up until the point of birth. Its lack of restraint on abortion was due to the U.S. Supreme Court's 1973 decision in Roe v. Wade, which judicially fabricated a right to abortion that supposedly emanated from the penumbras of the law. That fabricated right was partially affirmed by the Supreme Court in 1992 in Planned Parenthood v. Casey. On June 24, 2022, however, the U.S. Supreme Court corrected its previous misinterpretation of the U.S. Constitution and issued its historic decision in the case of Dobbs versus Jackson Women's Health Organization, which overruled Roe v. Wade and Planned Parenthood v. Casey. The court in Dobbs correctly held that the Constitution of the United States does not, in fact, confer a right to abortion. The effect of that decision has been multifaceted. Contrary to popular myth, the overruling of Roe and Casey did not create a nationwide prohibition of abortion. Rather, the court removed the abortion issue from its purview and restored to the states their constitutional authority to regulate whether and under what conditions abortion should be permitted within the state. Thus, each state is now free to legislate on the matter as its voters see fit. As such, abortion law in the U.S. is described best as a patchwork and diverse. Indeed, the 50-state patchwork of abortion-related laws will become even more diverse with time. Some states have taken a very liberal approach, enshrining a right to abortion within the state that extends well beyond the right that was thought to have existed in Roe and Planned Parenthood v. Casey. Indeed, after Dobbs, California has become one of the most pro-abortion states in the nation by passing a law that effectively decriminalizes certain forms of infanticide by restricting criminal investigations into the deaths of infants during the prenatal period, a period of time that extends up until 28 days after birth. The American Center for Law and Justice, ACLJ, has recently filed multiple records requests looking into the passage of that bill. Other states, like Colorado, have passed laws declaring abortion a, quote, fundamental right. Further, citizens in California, Michigan, Oregon, and Vermont recently voted on whether to amend their respective state constitutions to create a right to abortion. California, Michigan, and Vermont voters voted yes to amending their constitution to create a right to abortion. Montana voters also voted against born alive protections, which would require health providers to attempt to save a baby born alive during an abortion. On the other hand, there are states that have demonstrated a regard for the value of prenatal life by implementing restrictions on abortion. 3 states, Alabama, Arizona, and Louisiana, have constitutional amendments to protect preborn life. Similarly, Tennessee and West Virginia amended their constitutions to state there is no right to an abortion. Around 15 states are currently trending towards effectively enforcing their restrictions on abortion. While no state has banned abortion completely, many have very limited permissions, and there is reason to believe that more states will trend toward protecting preborn life. A significant victory for protecting preborn life was recently achieved in South Dakota. For years, Planned Parenthood fought South Dakota's common sense regulations on abortion. After decades of litigation, the ACLJ was asked to step in and represent Governor Noem and the state in its battle to enforce its abortion regulations. Soon after the Dobbs decision was released, and with ACLJ's representation, the preliminary injunction against South Dakota's law was dropped and the appeal dismissed. The danger that now exists at the state level is that state courts will attempt to wrongly exercise raw judicial power to strip state legislatures of their right to regulate abortion, raising significant separation of powers concerns that extend well beyond the issue of abortion. This is, in fact, what abortion advocates are seeking and asking their courts to do in challenges to state laws protecting preborn life. Alabama, Arizona, and Arkansas, for example, prohibit abortion except in the life of the mother situation. Georgia, where I'm from, Louisiana, South Carolina, and Tennessee have laws that prevent abortion after the fetal heartbeat is detected. Injunctions are being sought against many of these laws. 10 states are facing litigation over their pro-life statutes, which have implemented limited abortion policy, and 7 states with moderate abortion policies are also facing litigation. Most of the challenges at the state level argue that there is a right to abortion in the state constitutions. State courts, however, must be careful not to create a state constitutional right to abortion hidden somewhere within the text of the state constitution, and thus setting themselves upon the same long and tortured path the U.S. Supreme Court stumbled along for 50 years. The ACLJ has been actively working to support the pro-life states facing legal challenges. For example, in Idaho, the ACLJ filed an amicus brief in support of the Idaho abortion regulation, which is under attack by the U.S. Department of Justice. In South Carolina, the ACLJ filed an amicus brief in defense of the South Carolina pro-life laws, which restrict abortion after 6 weeks of pregnancy. In Kentucky, the ACLJ filed an amicus brief with the Kentucky Supreme Court in support of the state's pro-life laws prohibiting abortion after a fetal heartbeat is detected. The ACLJ has also filed an amicus brief with the Oklahoma Supreme Court in support of Oklahoma pro-life laws under attack. And in Michigan, the ACLJ filed 2 amicus briefs in the Michigan Supreme Court in support of a Michigan statute restricting abortion and against the governor of Michigan's lawsuit that advocates for a state right to abortion. Now that Dobbs removed the Roe restrictions on states, some states have conflicting laws regarding abortion that require clarification. For instance, Arizona enacted a strict abortion ban in 1901, but its legislature has passed dozens of abortion-related laws since Roe. Pro-abortion advocates are asking the court to clarify whether the 1901 law preempts the latter laws. In Wisconsin, pro-abortion advocates argue in court that a 1985 statute that allows pre-viability abortions supersedes the state's 1849 broad ban against abortion. The aftermath of Dobbs is also felt at the federal level. You understand, we have a federal republic. We have a central government, and then we have 50 sovereign states. The battle has now moved from the federal level to each of the 50 states. That's the bottom line here. The ACLJ is involved in numerous matters at the federal level as well. Earlier this fall, the U.S. Department of Veteran Affairs issued a new rule without following the usual procedures and in direct violation of federal law. This new rule purports to allow the Veterans Administration to perform abortions in certain circumstances for the first time in the history of the VA. You see, what they're trying to do now is saying, we'll get around Roe v. Wade by saying you have a federal right to abortion if you go to a veterans hospital, which is administered by the federal government. The ACLJ challenged the new rule by submitting a comment with legal analysis in response to the VA's interim rule change permitting abortions in its facilities. The rule change violates long-standing federal law directly on point that prohibits the VA from performing abortions. Medical staff at the federal level will potentially see their conscience rights violated. The Department of Health and Human Services has proposed a rule change to allow medical staff to be forced to perform abortions. HHS, Health and Human Services, makes the assertion that refusing to provide abortion-related services is somehow unlawful sex-based discrimination. However, the Supreme Court rejected that very argument and stated that opposition to abortion is not an invidiously discriminatory animus against women, and the Supreme Court affirmed that holding in Dobbs. The ACLJ is currently representing 2 clients in federal court on the issue of buffer zones. Buffer zones prohibit counseling outside abortion businesses. After Dobbs, the application of a key precedent has shifted, allowing a way forward for the rights of ACLJ clients and many more to be protected. The case of 2 current clients are in different circuits. If the circuits interpret precedent differently, the issue may reach the United States Supreme Court. Finally, the ACLJ takes a strong stand on protecting pregnancy resource centers. Pregnancy resource centers provide free or nominal cost to millions of women in the United States annually, including hundreds of thousands of free ultrasounds, along with medical services, education, and referrals. In 2019, over 10,000 licensed medical professionals served as paid or volunteer workers in 2,700 pregnancy resource centers across the United States. Thousands more people serve voluntarily at pregnancy resource centers on an annual basis. Pregnancy resource centers save taxpayers millions of dollars each year, again because many of the services they provide are free through volunteers or donors, when otherwise they would have to be provided by government agencies through taxation. Pregnancy resource centers provide invaluable information and resources that help ensure that women are fully aware of all the facts and options available to them to help them inform their decision and truly give them choices, including the fact that abortion intended to permanently end the life of an unborn child, an act that is extremely grave, gruesome, and irreversible. We believe a woman's decision should be fully informed. What's wrong with that? Nothing wrong with that. And should be made only after careful consideration of all the facts. One option does not constitute choice, and therefore pregnancy resource centers play a vital role in providing alternatives to the only option pushed by abortion clinics. Moreover, pregnancy resource centers provide material assistance and support beyond merely consultation or medical services. As such, we expect that pregnancy resource centers, their healthcare workers, and parents, patients, will be provided the same vigilant protection that the Department of Justice is dedicated to providing to abortion clinics and those women seeking abortion in the weeks ahead. At the local and state levels, cities and states are passing laws to target pro-life pregnancy resource centers for investigation in an attempt to shut them down. We are doing our best to prevent that from happening. A pregnancy resource center in Buffalo, New York was firebombed. In addition to being firebombed, vandals sprayed the phrase, "Jane was here," onto the building, referencing the pro-abortion anarchist group Jane's Revenge, which took credit for attacks on pro-life organizations that occurred the weeks before in Wisconsin and Washington, D.C. 3 days later, at a pregnancy resource center in Oregon, an incendiary device, a firebomb, was thrown through a window, lighting the facility on fire and leaving one office and other parts of the building with extensive damage. 1 month later, on July 8, 2022, President Biden issued an executive order on protecting access to reproductive health care services. The order threatens the vital work of pregnancy resource centers. The ACLJ responded to President Biden's executive order by sending 4 letters containing legal analysis, one to Secretary Becerra, one to Secretary Mayorkas, one to the chairman of the Federal Trade Commission, and one to the Attorney General of the United States. While the executive order is troublesome, of particular concern are the portions of the order that call on federal departments to consider options to address deceptive or fraudulent practices related to reproductive health services, including online, and to protect access to accurate information. None of the attacks or calls to violence that I have told you about just now, none has been condemned by President Biden or his administration. And by ignoring them, the Biden administration appears to be generating its own false or misleading and dangerous narrative that pro-abortion violence does not exist. Instead of quelling the division, officials are fueling and adding fire to the flames. On June 17 of this year, pro-abortion members of Congress sent a letter to the Chief Executive Officer of Google. In that letter, members of Congress referred to crisis pregnancy centers or pregnancy resource centers as fake clinics. The letter goes on to call Google to limit the appearance of fake clinics or so-called crisis pregnancy centers in Google search results, Google Ads, and Google Maps. The Attorney General of New York wrote a similar letter to General Counsel for Google. These are just a few examples of the attacks on pregnancy resource centers that the United States is facing. The ACLJ is working with centers across the country to defend their rights and fight these attacks. In conclusion, there is an end. I'm coming to it. Abortion is a profoundly divided issue within the United States. You know that. The Supreme Court's ruling in Dobbs has ushered in the United States a new era. Only time will tell if the United States will continue to live up to its international outlier status as one of the most barbaric places on earth for preborn children, or if it will come together to be a champion for preborn human life, the most innocent and marginalized of all human beings. In this new era, the ACLJ will not only continue to do what it has done since its creation, fight for innocent life, it will increase its efforts. There is no doubt in our minds that championing the cause of the preborn is the bedrock of championing justice for all. Thank you. Merci.